Good morning, everyone. I would like to call this meeting to order. Welcome to Assembly Judiciary. And with that, Mr. Tamani, will you please call the roll?
Assemblywoman Bilberry Axelrod.
Here.
Assemblywoman Cohen. Here. Assemblywoman Considine. Assemblywoman Gallant.
Present.
Assemblyman Gray.
Here.
Assemblywoman Hanson.
Here.
Assemblywoman Hardy. Assemblywoman LaRue Hatch.
Here.
Assemblywoman Marzola.
Here.
Assemblywoman Mosca.
Here.
Assemblywoman Newby.
Here.
Assemblyman Orntlicker. Assemblywoman Summers Armstrong.
Present.
Assemblyman Urick. And Chair Miller.
Here.
Thank you, and please mark anyone that's not here present when they do arrive. Today, just so everyone knows, we have 3 presentations, and of course that will be followed by public comment. We also have video conferencing accessibility in Carson City today, and so maybe people will arrive and view and participate later. With that, just a few housekeeping issues. Remember asking everyone to turn down anything that makes any kind of noise, just to turn it down. Also, agenda items may be taken out of order. We've mentioned that multiple times before, and today we are going to take our presentations out of order. With that, again, please remember those that are presenting to make sure there's 20 copies given to the committee secretary prior to your testimony. And of course, everyone can follow along on Nellis or watching through the legislature's YouTube page. When we get to public comment, we will allow 2 minutes per person to speak upon any issue that is under the purview of this committee. And with that, I would like to open up our presentations, and we will begin with our first presentation, which is an overview of Clark County and Washoe County offices of the District Attorney. We have Chief Deputy District Attorney John Jones from the Clark County District Attorney's Office and Chief Deputy District Attorney Jennifer Noble from the Washoe District Attorney's Office. And just so that everyone knows, our next presentation, again, it's out of order from the agenda. It will be from the Department of Public Safety, and then the last one will be from the State Board of Parole Commissioners. So we are ready whenever you are, so. Please proceed when you're ready. Do you need another moment or?
Thank you, Chair Miller, and good morning. We are good to go now. Good morning, Chair Miller and members of the committee. My name is Jennifer Noble, and I am a Chief Deputy District Attorney in the Washoe County District Attorney's Office. And joining me in this presentation today is Chief Deputy District Attorney John Jones, who is working in the Clark County District Attorney's Office. So in addition to being full-time deputy district attorneys, we are also the legislative liaisons for our respective elected district attorneys, Steve Wolfson and Chris Hicks. The District Attorneys Association, which we also represent, is composed of the 17 elected district attorneys in Nevada. And this is my 4th session talking to the Judiciary Committee. It's John's 7th, and we are very excited to be here and hopefully help you in whatever way you would like in understanding any aspect of criminal law and talking to you about issues that are important to Nevada. I hope that those of you returning to the committee know that we earnestly work to find common ground with stakeholders, and sometimes we don't quite get there, but it's never without sincere effort and also the understanding, even when we disagree, that we are all here, everyone in this room is here trying to serve Nevadans in the best way that we know how. So, what does a district attorney do? There's been a lot of attention and examination, and appropriately so, in recent sessions regarding district attorneys, prosecutors, and our role in the criminal justice system. And I'm sure you've seen Law and Order or other shows that depict DAs, and also in the media. We're often portrayed as folks who just want to win. We don't care about what the truth is. We just want to win, and that couldn't be further from the truth. That makes dramatic television, but in reality, we are bound by the constitutional law, by our ethical obligations, and by the truth, and that is our job. and we take these obligations very seriously. Today, I'd like to share with you some ways that Nevada prosecutors have been updating their approach to prosecution in recent years, and let you know about some programs that we work with frequently. Now, it doesn't mean that we are going to support every criminal justice bill introduced this section, but with every criminal justice bill that we see, we're absolutely committed to working with stakeholders in good faith, and we are committed, like all of you, to an equitable criminal justice system that benefits us all. So what do we handle? District attorneys handle misdemeanor crimes that occur in a county jurisdiction, and that doesn't include city jurisdictions. We handle all gross misdemeanor and felony cases. And while most of this presentation today will focus on our job as criminal prosecutors, DAs are involved in many facets of government administration in Nevada. That includes juvenile cases, child support cases, and child welfare. We also, our civil divisions, represent county boards and agencies, similar to how the Attorney General's office represents state boards and agencies. And John and I would also like to take this opportunity to invite you to come to one of our offices if you would like to shadow a prosecutor or learn more about what we do. It might not be as exciting as a ride-along that some of our law enforcement friends may be able to offer you, but it might give you some insight into what our day is like and how we do our jobs.
Thank you, Chair Miller, members of the committee, John Jones, on behalf of the Nevada District Attorneys Association and the Clark County District Attorney's Office. Every county in Nevada has its own elected district attorney, and the various DAs in Nevada are as diverse as the Nevada landscape. We have offices where the only attorney in the DA's office is the elected DA themselves. And at the other end of that spectrum is my office, the Clark County DA's office, in which we are one of the larger prosecution agencies in the nation. And we have to be mindful of those differences in office sizes when making legislation and the impact that that legislation has on some of our smaller jurisdictions. Specifically turning to the Clark County District Attorney's Office, we have 5 major divisions. We have the Administrative Division, the Civil Division, Criminal Division, Juvenile Division, and Family Support Division. There are about 175 attorneys, and that it varies widely. Much like other public agencies, we are having difficulties in both recruitment and retention of attorneys. But right now we're at about 175 attorneys. And that includes about 120 in our criminal division and around 30 in our juvenile division. The remainder are spread between our civil and child support divisions. Lisa Logston leads our civil division. She acts as county counsel to the Clark County Commissioners and provides legal counsel to the commission and other county agencies. Our juvenile division is led by Bridget Duffy. Many of you have worked with Bridget on various issues, and she will be a regular presence in front of this committee on bills that affect children in Clark County and in the state. And it surprises people to learn that while the criminal division has the largest number of attorneys, our actual largest division in terms of number of employees is our child support division. And our child support division goes after parents who are not adequately providing support for their children. The focus of this presentation today will mostly be on our criminal division. And I've spread out here our criminal division for you to see that we have broken it out into specialty areas. Sometimes an area of law requires a special skill or knowledge base in order to successfully prosecute a case. So we have our homicide unit, which handles most of our homicide cases, gun crimes unit, which handles cases involving the use of a firearm, our special victims unit, which involves sexual assault cases or cases where the children is a victim of either sexual or physical abuse, our gang unit, which works closely with gang detectives in Las Vegas, and our HIDA, which stands for High Intensity Drug Trafficking Area. That's a collaboration between state, federal, and local law enforcement agencies and does include our office. They handle high-profile and drug cases that involve a significant amount of drugs.
So the Washoe County District Attorney's Office is smaller, and it's set up a bit differently, but in terms of the child support division, we do the same thing. We also have 3 felony teams which handle a wide range of felonies from drug trafficking to sexual assault. Our intake team appears at pretrial release hearings, and it also handles the initial charging of some felony cases. Our major violators unit handles our most egregious, aggravated Category A felonies, like sexual assaults, homicides, etc. We also have a misdemeanor team that handles all misdemeanors, and also a team of prosecutors who handle cases in the juvenile justice system. Additionally, of course, we have a civil division that acts as the county council, family support division, and child welfare division. I oversee the appellate team, and we handle all appeals to the Nevada Supreme Court and the United States Supreme Court regarding criminal cases. Our Child Advocacy Center is also on this slide, and those prosecutors serve our youngest victims in the community. We also have a Victim Witness Assistance Center, investigations team, and Conviction Integrity Committee, which I'll speak about a little bit more later. So when we're talking about prosecution in the criminal divisions of our offices, we like to focus on the 3 Ps: protecting victims, prosecuting crimes, and promoting justice. And justice can look different in every case. We have victim services, such as the Victim Witness Assistance Centers, and we work with community partners to make sure that the constitutional rights of victims are protected as well, and that we are always keeping the interest of the community in mind when we're evaluating our cases. The Victim Witness Assistance Centers of our offices provide services to victims such as advocacy and court accompaniment. They notify victims about what's going on in their case, update them. They direct them to community resources, and also network and collaborate with those resources and agencies to support victims and their families in what is often the most stressful time of their lives. Some of the community partners that we work with are Victims of Crime, Safe Nest, Safe Embrace, the Rape Crisis Center, Legal Aid Centers, the Children's Cabinet, and the Housing Authority. In Washoe County, we are particularly proud of our Child Advocacy Center, which is accredited by the National Children's Alliance. This is a multidisciplinary team that provides wraparound services to children who have been sexually abused, physically abused, or suffering from serious neglect. The multidisciplinary team includes physicians, nurses, mental health providers, law enforcement, prosecutors, and specially trained forensic interviewers who are trained to talk to children about what happened to them. It uses an evidence-based approach to minimize further trauma to the children, and it's a very child-centered building. And I invite you to come tour it and talk to the people who work so hard for our smallest victims. It's a really wonderful place, and I think that you'd be very, very pleased to see what they're doing there. We want to maximize the support and the resources for each of these children and their families. It's child-centered, it's a special place. Please come down, and if you have time in Reno, take a look at what they do there. I think you'll be very, very pleased. In 2018, as many of you know, or probably all of you, the Nevada voters passed what is commonly known as Marsy's Law. Marsy's Law is a constitutional amendment that provides specific guarantees to victims under the Nevada Constitution. These rights include the right to be present at any hearing, the right to be present at any hearing regarding pretrial release, sentencing, bail, and the right to have their case handled in a timely fashion. Because as I'm sure you can appreciate, and I'm sure some of you have been at some point or known someone who is a victim of a crime, the justice system moves somewhat slowly, and so we try to make sure we move the cases along at a reasonable pace, keeping in mind that these victims' lives are often put on hold while they're waiting.
John Jones on behalf of the Nevada District Attorneys Association. And before I move on to the next slide, I do want to point out that our obligation, the obligation to protect victims' rights falls on everybody in the criminal justice system. Oftentimes people assume that it is just the prosecutor's responsibility to protect victims' rights, and that is not what Marsy's Law says at all. That responsibility falls to all of us. Our next slide is prosecuting cases, and this is probably what prosecutors' offices are most known for, even though we engage in many other activities. But from making a charging decision to bail arguments at prelim, trial, and sentencing, a DA's power to hold people accountable for their crimes is carefully defined by the law and our ethical responsibilities. And throughout the process, there are checks and balances and layers of accountability, be it from a judge or defense attorneys. And the first and arguably the most important decision a DA will make is whether or not to charge somebody with a crime. When someone is arrested, we carefully review the facts of the case and the evidence in order to determine whether or not we should be filing charges. The larger offices, Clark County and Washoe, have attorneys whose sole job it is to review or screen cases. I can tell you that in Clark County, we have 10 attorneys who handle that responsibility, and all 10 of them are seasoned attorneys. And we use seasoned attorneys for a reason. They can best answer the difficult question of, is there enough admissible evidence that would allow us to prove this case beyond a reasonable doubt? And there are many factors that go into a charging decision. We review the case for any proof, constitutional or search issues that would affect our ability to prove that case beyond a reasonable doubt. And I want to be clear that our charging decisions are independent of the law enforcement agencies that refer cases to us. And in Clark County, in the COVID pandemic and other factors led us to review and revise our charging guidelines. Charging guidelines are the standards that a deputy must consider when deciding whether or not to approve or deny a case. In addition to updating our charging guidelines, we also had 2 deputies who spent several months going around to the various law enforcement agencies and training them on our new guidelines. We set these new requirements with the intent of the materials and the things that we're going to look for and that we require prior to filing a case. And we are holding law enforcement to those guidelines. And I think that's borne out in the statistics. In Clark County, in 2018 and 2019, we were approving approximately 80% of our felony cases in any given year. Since the new guidelines have been implemented, we're approving about 60 to 66%. So around 2/3 of our felony cases are being approved for prosecution, with the remainder being denied. So that means over 30% of the felony cases referred to our office in any given year are denied for prosecution. And I want to be clear that this does not mean that law enforcement is in any way deficient. It's a function of how our system was designed to operate and a product of the different burdens of proof under which each entity operates. Law enforcement is focused on probable cause. Is there slight or marginal evidence to arrest somebody? Is there slight or marginal evidence that a crime has been committed? If there is PC, an officer may, and in some instances must, make an arrest. But my obligation as a prosecutor is whether or not I feel I can prove the case beyond a reasonable doubt. That is a much higher and much more difficult standard. I want to take a look at the home invasion and residential burglary, kind of to illustrate this point. And I'm going to use Jenny as an example here. She's upset with my performance today, so this evening Jenny comes to my house and kicks in my residential door. She starts yelling me about my deficient performance and balls her fists. I, of course, call the police because she's kicked my door in. The officers come, they interview all the parties involved, and they decide to make arrest on a residential burglary because Jenny entered my structure unlawfully. I didn't give her permission, with the intent to commit an assault or battery. She was balling up her fists, she was yelling at me, and so I think the officers made an appropriate arrest. Now, I, as a prosecutor, get that case, I read the facts, and I say, maybe home invasion is a better charge. because she used force, kicking in my door, to enter my residence. So I may deny the charge that the officer arrested on, the residential burglary, and approve an alternate charge, that of home invasion. That happens all the time. That is a regular function of our job as prosecutors, and it just sort of illustrates the different roles that we play as prosecutors. Once we determine that we are going to file a charge, we file a criminal complaint. Now, a criminal complaint looks similar to the document that you see on your screen. Now, there are variations amongst counties, but this is one that we file in Las Vegas Justice Court, charging one count of home invasion. And it spells out the particular facts of each case that I, as a prosecutor, are alleging that the defendant engaged in. At the same time, we're considering whether or not we should file charges. The courts are holding what we've now stylized in Nevada as Valdez-Jimenez hearings. Valdez-Jimenez is a recent Supreme Court case that outlines that a defendant is entitled to a prompt, individualized bail hearing, and that if bail is set in an amount more than the defendant can afford, then the state must prove by clear and convincing evidence that there are no less restrictive alternatives. So I want to be clear in this, is that bail can be set in an amount that a defendant can't afford. But I, as the prosecutor, have to prove that there are no less restrictive alternatives that will both protect the community and ensure that the defendant will appear again in court. Now, the Nevada Constitution and the NRS specifically outline what factors a court is to consider when deciding whether or not I have met my burden or whether or not a bail should be set and in what amount. Additionally, last session, the legislature passed two bail reform measures, SB 369 and 424, AB 424, that both codified Valdez-Jimenez and specified that a defendant has to see a judge within 48 hours of arrest. Now, I do want to point out that the 48-hour requirement has imposed a huge burden on the criminal justice system. When I talked about some of our smaller DA's offices and smaller court jurisdictions, they were not staffed to have court run 7 days a week. And with a 48-hour system, you have to have courts up and running 7 days a week. You don't know when people are going to be arrested, and with the 48-hour requirement, you've got to be ready at any given moment to have a bail hearing. Now, in Las Vegas Justice Court, we have what's called the initial appearance court. That does run 7 days a week, and it has a goal of getting defendants in court in front of a judge within 12 hours of arrest. And I want to point out that that is a noble goal, to get defendants in front of judges quicker. But I do want to point out that we can't rush the process so much that we're not doing an adequate job of looking into the defendant's history and whether or not they are a flight risk or a threat to the community. When you rush the process, you're also rushing the decisions. And when you rush the decisions, you end up with outcomes that may not be in the best interest of the community. Now, judges have other options other than bail. They have house arrest, which involves an ankle monitor. We have intensive supervision. Judges can also set conditions of release in lieu of conditions or bail. In fact, Las Vegas Justice Court has developed a program where they give defendants cell phones as a condition of release to ensure that they can get notifications and for monitoring purposes. Again, I do want to stress, though, that having enough time to make informed decisions about release is imperative. A few days after the bail determination, the initial arraignment is held. And after the initial arraignment occurs, we begin negotiations with defense. And we look at a number of factors when we're thinking about negotiations with a case. The first is obviously the strength of the witnesses. When you have witnesses who write statements saying, "I think I saw," versus "I saw," or "kind of remember" versus "I remember," those sort of weigh in with respect to how we're ultimately going to negotiate a case. Additionally, you have the seriousness of the offense, and again, our ability to prove the case beyond a reasonable doubt at trial. Details in the officer report, the criminal history, and even the victim's age all play a role in how a case will ultimately be negotiated. And I want to point out that no two cases are the same. Cases that are seemingly similar are often not. I also want to point out that most cases negotiate. We file generally between 20 and 30,000 felony cases in Clark County every year, but only around 150 in any given year actually proceed to jury trial.
In preparation for trial, of course, the state and the defense do a lot of work to make sure that the trial goes in a manner that the jury has all the evidence necessary to make its decision. So in preparing for trial as prosecutors, we review and evaluate all evidence submitted by law enforcement carefully, and sometimes we may ask them to conduct additional investigation into an aspect of the case. And in criminal trials, prosecutors are the only attorneys who have a unique obligation, not only to provide to the defense all of the evidence that we plan to use against the defendant at trial, but also anything that is exculpatory, meaning it might tend to negate or disprove one of the charged offenses or an element of those charges, as well as any material impeachment evidence. And that simply means evidence that might tend to question a witness's credibility. If we don't do that, we violate the United States Constitution, and so we take those obligations very seriously. Both the state and the defense have the ability to subpoena witnesses, to file motions regarding the admissibility or non-admissibility of certain pieces of evidence in a case. At trial, we have a defendant in Nevada has a right, and everywhere has a right to a jury trial before a panel of their peers. In felony cases, that's 12 jurors, and 6 in misdemeanor cases. Those jurors must make the factual determinations that ultimately lead to their verdict of guilt or innocence regarding the defendant and the charges. Every element of the crime must be proven beyond a reasonable doubt. The defendant does not have to testify. The defendant does not have to present any evidence whatsoever. And the decision of the jurors must be unanimous regarding guilt. So what exactly is reasonable doubt? In Nevada, we have a statutory definition of reasonable doubt, which is on this slide, but basically it's one based on reason, not mere possible doubt, but something, a type of evaluation that you might use in the more weighty affairs of life. As DAs, we do not stray from this definition, and we welcome this burden. To convict anyone of any offense, we have to do our jobs and prove every element of the charge offenses beyond this standard. If we don't do that, the jury must do the right thing and acquit the defendant. At sentencing, that usually happens between 2 and 6 months after a guilty plea or jury verdict. The Division of Parole and Probation provides a report that contains the background information of a defendant. That can include their criminal history, their personal history, including what they may have suffered as a child, issues with addiction, anything that might be relevant to a court considering this person not just as somebody who's been convicted of criminal charges, but as somebody with a history that informs perhaps what they did in this particular case. Both the prosecutor and the defense attorney argue for a sentence within the range prescribed by a statute, or if there's a plea negotiation, then we would confine our arguments to the negotiations and follow those. But ultimately, it is up to our elected judges, our elected district judges, to use their discretion and fashion a sentence that they believe is appropriate for the defendant. We also have what's called, I'll call post-conviction proceedings, and that's what I deal with a lot on a daily basis. So after a trial or a plea, the legal process continues actually for a long time, and that's the part that I don't really think you see on TV at all. After conviction, or whether it's a plea or a trial, a defendant can seek relief with the Nevada appellate courts, which includes the Nevada Court of Appeals or the Nevada Supreme Court. That's what we call a direct appeal. And then they can, at the same time, but usually afterward, within 1 year of their conviction, file a petition for writ of habeas corpus in the district court. And those petitions tend to talk about what they believe their defense attorney did wrong. And typically they are represented by counsel in the context of these petitions. And there can be other issues that come up, like juror error or different things, but essentially they challenge the job that their defense attorney did at trial, and it is up to the court to decide whether or not they had constitutionally adequate representation. Now, while we have that 1 year limitation, which actually starts if they file a direct appeal, after that appeal comes back to the district court and the case is affirmed, or if they don't appeal within 1 year of the judgment of conviction, there are actually a number of other procedural vehicles that defendants can use for relief. They can file a motion for a new trial, a request for DNA testing, a motion to withdraw their guilty plea in some instances, and a petition to establish factual innocence. And I think this is really important to understand because that has no statute of limitations. They could file that 1 year, 6 months, or 30 years after their conviction.
And John Jones on behalf of the Nevada District Attorneys Association. We've spoken earlier and often about how prosecutors are approving their practices. And one of the major ways is that we are focused on stopping the cycle of offending, getting at the reasons why people are breaking the law, be it drug addiction, mental health, or other triggers. But I want to state that there is still a punitive aspect to the criminal justice system. Prison is still an important tool to rid our society of those who prey on others. That being said, DAs are focused more on treatment, and this is where legislators come in. We need more options for drug and mental health treatment. One of the promises with the passage of AB 236 was that we would see more investment in these types of programs, and we are going to hold you all to that promise. I can unequivocally say, and I think everybody involved in the criminal justice system will unequivocally say, that the options that we have now are not sufficient. That being said, we do try to engage in what we call diversion. That means giving people who have committed offenses second chances. We've got several types of diversion that we engage in, and the first is a program that we have in the Clark County DA's office. Under the direction of Steve Wolfson, we created a pre-charge diversion program called Project Redirect. It's modeled after similar programs in other DA's offices, where we work with county agencies and help connect defendants to needed services. If a defendant completes the program, charges are they are denied. I'm also showing we have diversion in statutes such as 3363 treatment. It's a program that allows low-level drug offenders to receive a diversion and an opportunity for treatment and a dismissal. Additionally, we have diversion in negotiations. In other words, even though it's not a statutory or formal program, oftentimes I, as a district attorney, will work with defense to fashion a type of diversion wherein they'll plead guilty, attend classes, pay a fine, or maybe complete some community service, and ultimately I will dismiss the case as long as those conditions are complete.
Jennifer Noble on behalf of the Nevada District Attorneys Association. So I want to talk a little bit about the specialty court systems, particularly in Washoe County and Clark County, which are much more robust than they were in the past, but we can always use more. Because what we'd like to do, whenever possible, is set a defendant up for success. And that means getting them the appropriate treatment. For example, many offenders have drug problems, substance abuse issues, and so we refer those folks, when possible, to drug court, which has services such as treatment providers, housing assistance, and employment assistance. And we separate those offenders into separate dockets based on their risk and their need. So if we have a sales-related offender, they might be in a different drug court class than someone who's just struggling with addiction issues. And of course, we have mental health court. Now, it's worth noting, and I'm sure you all know, that often folks use substances because they are coping with a mental health issue. But it's really tough to get appropriate treatment for folks who are in the active phase of addiction. So that's why you may see people who are also struggling with co-occurring mental disorders in drug court initially. But our mental health court focuses on offenders who are primarily or in the criminal justice system because they have mental illness or some sort of condition that affects their cognition. This court provides wraparound services, including housing assistance, psychiatric services, and medication regimens where appropriate. And I should note that in the Washoe County District Attorney's Office, we have a specific team dedicated to working with these specialty courts. Often it's a very informal atmosphere where we have therapists, we have perhaps law enforcement, whatever probation officer might be supervising this person, and the judge, and they sit and talk about how they can best help this person and set them up for success. Our specialty courts also, of course, include Veterans Court. So that court is set up to treat those who have served our country, and it focuses on veterans with service-related conditions like brain injuries, military sexual trauma, post-traumatic stress, anxiety, depression, and it serves veterans throughout Nevada jurisdictions. Includes drug addiction treatment, mental health, and psychiatric services, and we collaborate with the Veterans Administration and veteran charities to connect participants with wraparound services such as subsidized housing, employment, and mentors, folks who have been there, who have served, and perhaps came back struggling with some of the same issues. And that program generally lasts 12 to 18 months. We also have in Washoe County a prison reentry court, and this is just a little bit of information about it, but you can also look on the Second Judicial District Court's website for more information. But these are offenders that are referred by the Nevada Department of Corrections based on their disciplinary and achievement records while they're incarcerated. The prosecutor, defense counsel, judge, and the Division of Parole and Probation will vote regarding applicants in terms of their admission. They also, in prison reentry court, try to help with transitional housing, substance abuse counseling, and mental health counseling as needed by the client. Participants have to participate for at least 1 year or until they're paroled. And we start setting them up for this court while they are still incarcerated so that when they exit, we can start having these services in place quickly. Additionally, we have DUI courts for folks who have driven under the influence, and misdemeanor specialty courts, which there are many of them, and they vary a bit from justice court to justice court. But I know that any of the justices of the peace in Washoe County would be happy to talk to you more. They're very proud of the work that they do in the misdemeanor specialty courts.
John Jones on behalf of the Nevada District Attorneys Association. Before I move on, I do want to say that DAs appreciate and use specialty courts. But I think that you guys need to know that in my experience, defendants really only want to go to specialty courts when prison is the most likely outcome of their case. In other words, the way diversion and specialty courts are written into statute, they're meant to be a front-end diversion program for people who are first or second-time offenders. However, the way we're using them, especially in Clark County, is for people who are really headed to prison. And it's difficult for us as DAs to get defendants to go to these specialty courts earlier in their criminal history, for lack of a better word. In Clark County, Steve Wolfson has also developed a program that we're calling Hope for Second Chances. It's a collaboration between the Clark County DA's office and the Hope for Prisoners program. And I will make a brief plug for the Hope for Prisoners program. If you guys have not had an opportunity to learn more about this program, please take it. It is an exceptional program that John Ponder has put together. And we work with them on another type of diversion. This isn't statutory. It's one that our office has come up with to work with deeper end offenders, but with a program, the Hope for Prisoners program, that really does work. Additionally, we have the Harbor. Bridget Duffy will be testifying in front of you next week, I believe, talking about the juvenile justice system in Clark County. And one of the biggest programs they've had is a an entity called the Harbor, which is a physical facility where children and families can go to be connected with services. This is a couple years old now. They went from one facility to multiple facilities, and it really is a great program.
Jennifer Noble on behalf of the Nevada District Attorneys Association and Washoe County District Attorney's Office. So both Clark County and Washoe County District Attorney's Office have mechanisms in place independent of our statutory scheme and those post-conviction procedural vehicles that I described to look at cases where there may be a conviction, but there are claims regarding actual innocence that appear to have at least some credibility. Washoe County District Attorney's Office has the Conviction Integrity Committee, which is composed of three attorneys, and one being the Assistant District Attorney. And then the Clark County District Attorney's Office has the Conviction Integrity Unit. Now, I want to note that these units were set up prior to, I believe in the 2019 session, the petition for factual innocence. So the standards that we use are very similar to those set forth in Nevada Revised Statute Chapter 34, which describes the criterion for petition for factual innocence. So we also have an independent court mechanism where a convicted person can seek that type of review independently of the court at any time. But for example, the Conviction Integrity Unit, Conviction Integrity Committee, we look for things like, is there reason to believe there was a false confession? Was there somebody who said that they witnessed something and now they're recanting their testimony? Do we have additional scientific evidence that tends to call into question whether or not this person really committed the crime? And so it's very important to us that we have the right people incarcerated for very serious crimes, and we want to make sure that if there's any reason to believe that we've got the wrong person, we have independent mechanisms to start that. And we can do that by taking actions like stipulating to excuse procedural time bars, agreeing to additional DNA testing or other types of forensic testing, examining newly discovered evidence, or in some cases, agreeing to dismiss the case.
John Jones on behalf of the Nevada District Attorneys Association. Another recent entity that's been created is the Nevada Prosecution Best Practices Committee. This is a collaboration of individuals from multiple prosecuting agencies, including city attorneys, DAs, and the Attorney General's office has had representatives on this committee as well. We also have the chair of our committee attends conferences throughout the country. So we're having conversations with what other DA's offices are seeing, issues that they're dealing with, and ways that we all can elevate ourselves in terms of how we treat people within the criminal justice system. This has been a great tool for us to use to get together and talk to each other about criminal justice, both in Nevada and throughout the country. And we want to leave you with this quote. It's probably the most important quote that we have, and that's: a prosecutor's primary duty is not to convict, but to see that justice is done. I would like to, Jenny and I would both like to take the opportunity to invite you all to a legislative reception that the Nevada District Attorneys Association is having in conjunction with the Nevada Sheriffs and Chiefs Association. The reception is this evening at 5:30 to 7:30, and it's at the Nevada State Museum. And you are all welcome to attend. There will be sheriffs and chiefs from throughout Nevada present at this reception, along with elected district attorneys and deputy DAs from around the state. So please come. We can have conversations, you have questions answered, and it's a great way to get to know members of your law enforcement community here in Nevada. And with that, both Jenny and I are happy to answer any questions that you may have.
Thank you for that presentation. And it's not often we get invited to receptions at the end of a presentation. So I'm not saying everyone has to take that as, try to include that, but it is a nice touch. With that, I will open it up to questions from members. And our first question is from Assemblyman Gray.
Thank you, Madam Chair. So going back to your new standards with charging and actually going through that, so you said it's dropped down to about 60% that you actually accept for charges. So the question on that is, have you seen a decrease in the number of cases referred to your office? And then part two of that question is, has your conviction rate gone up with your increased standards?
John Jones on behalf of the Nevada District Attorneys Association. The number of cases to our office have actually gone up. We've had about 58,900 cases in 2021, and in 2022, we're looking at about 65,000 cases. So the number of cases that law enforcement is sending to us has remained fairly consistent, because for the past few years, we've hovered around 60,000 cases. It's gone up or down in any given year. In terms of convictions, we're only a couple years in to our new charging guidelines, so we're not at the point now where we can really look and see, is there any meaningful change? But we're hoping as we proceed forward to look at that data.
And Chair, if I could just add a little bit that I believe is responsive to the Assemblyman's question. Jennifer Noble on behalf of the record. The Washoe County District Attorney's Office recently, after a lot of work by senior prosecutors, revamped and clarified its charging standards as well. That's been very recent, so I don't have charging standard change statistics for you, but that is available on our website. You can see exactly the process that we go through and the requirements of law enforcement in terms of what they submit for any criminal case. So that's available on the Washoe County District Attorney website. Thank you.
Thank you. Our next question is from Assemblywoman LaRue Hatch.
Thank you, Chair. Thank you so much for coming here this morning and presenting to us. My question is on sentencing. You mentioned that sentencing usually happens 60 to 120 days after the plea or guilty verdict. And I just wondered, what is happening to the defendant during that time? Are they being held somewhere? And are they in a legal limbo? What's going on during that time?
Jennifer Noble, for the record. Thank you for the question, Assemblywoman, I'm sorry. So what's happening is that they're typically held at the Washoe County Jail, for example, pending sentencing, because some of the prisons are further away, right, and they haven't been sentenced to prison yet. Sometimes they'll get probation, so we don't know where they're going to go. They can move to be released pending sentencing, and that does happen when there are certain assurances of community safety and that the person will show up for sentencing, because sometimes they don't. And that's up to the judge. The Division of Parole and Probation also works on preparing a report in terms of making sure the court has all the information relevant. And also, their defense attorney needs time to prepare information that the court might need to hear, and witnesses to testify on their behalf at sentencing. And so that time allows both sides to formulate their arguments, present, and make sure that the victim can attend, make sure that the folks who the defense want to testify can also attend. So they are typically in custody during that time, but depending on what's going on, they may be out of custody.
John Jones on behalf of the Nevada District Attorneys Association. A few things I want to point out is that post-guilty finding by a jury or guilty plea, they are no longer cloaked in the presumption of innocence. So the standard with respect to detention is a little different. I'd also like to point out that the time varies so vastly is because defendants who are in custody receive the shorter sentencing date. So when you're talking about closer to 60 days, you're talking about a defendant who's in custody. And that 60 days gives PMP an opportunity to prepare the report, like Jenny said, and then also gives us time to notify the victims of sentencing. And the last point I want to make is that defendants in custody during this time receive that credit if they are ultimately given a prison sentence. So it's not dead time. It actually contributes to the calculus of their underlying sentence.
Thank you. Our next question is from Assemblywoman Hanson.
Thank you, Madam Chair, and it's good to see you, Good to see you all. I always say this, I think, at the beginning of a session. It's my third session on Judiciary. Don't have a legal background, but daughter of a DA, but certainly very partial to public defenders. So I always say we're trying to find that balance between justice and mercy, and that's what we really hope to do here in this committee. My question was, Mr. Jones, it was something you mentioned in the presentation that it's harder to use diversion in the process sometimes for people going to prison. Did I get that right? And if I didn't, clarify, and why is that?
John Jones on behalf of the Nevada District Attorneys Association. It's harder to get initial, how do I want to say this? People whose first contact with the criminal justice system, who may have a significant need that one of our specialty courts can address, be it mental health court, drug court, or even veterans court. It's harder to get defendants to sign up for those programs, even if it's a need that they have when it's their first or second contact with the criminal justice system. And I point that out because when you read these courts in statute, they're actually designed to be courts for a diversion court. So first or second time offenders who we try to get them the treatment, send them out the door, hoping that they never offend again. But in Clark County, what we actually see them being used as prison diversion courts, where people who are looking at the option of prison actually say, oh no, now I want to do drug court, or now I want to do mental health court. So the way they're written in statute is not really how they're being used in Clark County.
Chair, can I just follow up real quick?
Actually, we're going to move on
Okay.
because we're
On time.
pinched for time, so, and I still have a number of questions, but
I'll
thank you.
ask you at the reception.
Please ask it loudly so everyone can hear as well. Next, we have a question from Assemblywoman Considine.
Thank you, Madam Chair, and thank you so much for this presentation. I have a question on data. On talking about the charging decisions, do you guys often, when you're denying or approving, do you keep that data? Is there somewhere we can say, or we can find the data where charges were denied or they were changed, and we can kind of get an idea if there's other certain areas where they get changed more often than not? Is that data available?
John Jones on behalf of the Nevada District Attorneys Association. Some of that data I can get you in terms of charging changes and the like. I don't know if that's available, but I will ask members of my office to see if I can get that data for you.
Jennifer Noble on behalf of the Nevada District Attorneys Association. Assemblywoman, there's also that type of data in our office, the Washoe County District Attorney's Office. Probably we have more reliable data with respect to cases that are submitted through warrant. So for example, the person is not arrested, law enforcement isn't sure whether or not they should make an arrest, or in the case of a domestic battery, they haven't been able to locate the defendant within the 48-hour time frame. So those cases are submitted to our office for review, and I believe we've got stats regarding those denials or approvals for charging. We have changed because our criminal justice system vendor, the program is no longer available, so we've recently had to switch to a different criminal justice software. And we pulled some data, but we had some questions about the reliability of that data, so our IT folks are working on it. But I'd be happy to talk with you offline more about that.
And we have two more remaining questions. The next one will be from Assemblywoman Summers Armstrong.
Thank you, Madam Chair, and thank you so much for the presentation. A lot of good information. At the beginning of your presentation, you mentioned the Valdez-Jimenez decision, and that it is you're having a hard time with some of the rural areas to meet the 48 hours. We received a presentation the other day from the state DA, and they mentioned that PD, thank you, I saw the face, so I got that, from the State Public Defender's Office, and they mentioned that most of the rural areas now have video conferencing capabilities, and because of COVID, and so we now have this tool that we can use. So could you kind of go into more depth why, with this technology in place, and the ability to meet. I mean, I know we do it in Clark County all the time where we see people on video screen. They don't even come to the court. Why is this still an issue? Thank you.
John Jones on behalf of the Nevada District Attorneys Association. There is a piece of the bail reform measures that passed last session that did include video conferencing, and we do appreciate that. It does make it much easier to conduct these hearings. However, you're still talking about a limited resource, and we're extending that resources now from 5 days to 7. So in the rurals, especially in the DA's offices that have one DA, that person is on call 7 days a week, 365 days a year. And, you know, if you give us unlimited resources, we can make anything happen. But the problem is, oftentimes, policy is passed by this legislature that does not include the resources that we need to make it happen. And so that was an example of bail reform last session. So our offices and other offices had to go to the counties and ask for more money. And in some instances, they got it, and in others, they didn't. And I want to point out that it's not just our rural jurisdictions. We have some city attorneys' offices and municipal courts as well who have struggled to implement bail reform. Again, there are some benefits and some good things that came from the bail reform statute. What we're saying is we've got to be mindful of the resources that it takes and the impact that it has on our criminal justice system.
Okay, thank you. We're going to move to our next question, our last one, from Assemblyman Orlicker.
Thank you, Chair, and thank you for your presentation. I have a question on the Marcy's Law slide. The last bullet point was the right to a timely disposition of the case. So I wonder how that, the interaction with that and the defendant's right to a speedy trial. So this could just reinforce it. Yes, we really mean it. Or it could come into conflict for the defendant who wants a delay to, mount their defense. So could this override a defendant's waiver of their right?
Jennifer Noble for the record, to Assemblyman Orlicker. I think that there is a natural tension that you've identified, Assemblyman, between the constitutional rights in Marcy's Law and a defendant who may need more time to prepare their defense. And so it is our judges who have to sort of weigh the constitutional rights of the victim as well as the constitutional right of the defense or the defendant to have adequate time to prepare their case. And so you will definitely see frequent continuances when our public defenders or our private defense counsel need more time to prepare the case. And so it's certainly not one where one overrides the other, but it's more of a balancing test. But you will not often see cases go forward where a defense attorney is saying, I absolutely have not been adequately prepared, because then we're setting up the trial, or I haven't had time to adequately prepare my client and the case, because then we're setting up the trial for reversal because we have an ineffective assistance of counsel claim. So we have the United States Constitution, our state constitution, but you're absolutely astute in identifying that tension. The court tries to negotiate it as best it can.
Thank you for that. And thank you for your presentation. Thank you. I will, we are going to go to again, we're taking items a little bit out of order today. So our next presentation will be from the Department of Public Safety with Director Tagliati, Deputy Director Brueggemann, and Administrative Services Officer Palmer. And again, I'm going to ask that presenters, again, keep to our request of 20-minute presentations, because again, many members have questions and I want to ensure that all members are able to ask a question. So with that, when you are ready, and also I just want to take note that we do have floor today. And so we want to make sure that we have time for all the presentations, all the questions. And again, it literally takes everyone in this building working to make sure we're on time, because that's a goal too, to make sure we're starting floor as close as possible on time as possible. So, and I know many of you in this room do respect time limits, and so want to make sure we're respecting that. So when you are ready, please proceed.
Good morning, Madam Chair. Good morning, members of the committee. I am George Tagliati. I'm Director of the Department of Public Safety. To my right is Sherry Brueggemann, our Deputy Director, and to her right is Curtis Palmer, our senior fiscal person, and to his right is Kim Smith, our public information officer. And we have a number of senior managers of the Department of Public Safety who are here today to answer any specific questions that you may have. So without further ado, I'll turn it over to Sherry for a presentation.
Good morning. I'm Sherry Brigham, for the record. And I just want to say the last session I believe I presented, we were in the same dilemma of time, and I was asked to quickly go through the slides. And I think I set a record. So I'm happy to do that for you again. And if I go too fast, please slow me down, or we can finish up with questions and I can go over details with you at that time. So I'm going to start off with our lead slide, State Police, because crime knows no boundaries. In one of our most recent presentations, the question came up, what would we do without the state police? And one of the problems that counties and cities have is they are limited by their boundaries and their rules. State police fills in all those gaps, ties up everything in a nice bow, and takes care of the things that the state legislators have requested us to take care of. Our state police also include all of our officers. So when we refer to ourselves as state police, we're referring to our investigators, our troopers, our P&P officers, our Capitol Police, our fire investigators. But as a group, we're state police. So for those of you who have the question, we are the Department of Public Safety State Police. Moving on, you see the org chart right behind that, and those are the fine people behind me, and you'll probably see much, much more of them throughout the session. We often testify on a number of bills. Happy to help. We're also happy to have conversations if you just have questions about a bill or something along those lines. The next slide, we have called this our Make It or Break It year. Our staffing shortage is very, very critical at this point. We are losing all of our officers to the local cities and counties, and there's an average of about a 25% wage difference between them, which is putting us in a very difficult spot. So this is our make it or break it year, meaning that if we don't get some kind of relief, we're not sure we'll be around here to testify for you next year or next session. The next slide is just, again, the separated versus hire ratio, how we are losing so much more than we are hiring, and we are doing just about everything we can. The next few slides are going to depict the different divisions within the department, and I am going to go through them quickly until we get to the meat of it, which is our operations. But our first couple of slides are the director's office, which includes our fiscal staff and our human resources staff. And our human resources staff has been augmented by 2 officers who act as recruitment officers, which has really helped a lot in holding on to the applicants when we get a question, to keep them coming in and setting up dates and times. They go out of their way to meet with high schools, colleges. It's phenomenal what those 2 individuals have done for us. So we found that that's been a really, really good edge for us. Our training division is our academies. We have one in the north and one in the south. We're struggling to fill them. Right now we have an academy due in March for the southern group, and we can't, I think we have less than 3 people. And to get through the backgrounds before then, we pretty much need to have it filled right now. So we are going to have to move that time date further down the road. And that continues to put us further and further behind. So filling the academies are just as difficult as maintaining and keeping the staff that we have. The Office of Professional Responsibility, these are the officers who do internal investigations. Our Capitol Police, you'll see probably as frequently as your own legislative police. We also now have a bomb dog, Honey. You might meet her along your travels. Very responsive, frequent naps, but she works really hard. Our Highway Patrol, this is the group you see most often on the news, or the lack thereof. And I believe there was a segment just last night on amount of wrong-way drivers, 823 in the last calendar year. And of course, the only thing between them and us is our highway patrol. And the fewer highway patrol, the fewer barriers we have to that kind of thing. The next page is more highway patrol. We do have our drug dogs that help us enforce our drug requirements along the highways. We still seize quite a bit of drugs and narcotics, and that is a primary target of ours as well. Although, again, with fewer highway patrol, we have fewer opportunities. The Office of Traffic Safety are the folks responsible for putting out the various educational commercials like "I haven't been in a crash yet." You will see those coming through. They do so much more. They bring in federal funds for the officers to do special programs like special DUI weekends, et cetera. Training, lots of training. Consumer awareness training, just about anything you can think of in terms of helping both the officers and the consumers, ourselves, the citizens, learn more about driving and taking better care of ourselves. They're also the ones who put out the traffic safety fatalities list. And I'm looking at the number and it seems really small, but it's been so high. Is that 382? For last year. And that is a significant increase over the previous year and even more so significant over the year before that. Our investigation division is our unsung heroes. You don't hear too much about them. We're at about, 19, 20 investigators for the entire state. They handle major crimes, they handle drug enforcement, and all of those issues that one law enforcement agency can't handle or another. So for instance, our smaller counties who can't handle a significant crime investigation will contact us. We will step in and take care of it. Our folks are in charge of significant task forces with regard to narcotics, pharmacies. I can't even go on how many programs they really have to handle. And we're at such minimum staffing that it makes it difficult to do anything as well as we used to be able to. They are also home of Safe Voice. I forgot to mention that. Safe Voice is an educational program. From education, they use our investigations division to maintain and man a 24-hour unit that takes phone calls from students, emails, texts, warnings of pending threats, suicides, that sort of thing. And if you were here several sessions ago, we had testimony from one of our call takers of a young student that they managed to save from committing suicide because they got there fast enough while they had her on the phone. So they're very touching stories, and they seem to really make a difference in the schools. State Fire Marshal. State Fire Marshal also handles investigation arson fires, again, throughout the state. They often handle most of the rural counties, but are called in even into Las Vegas to handle some investigations. They also are in charge of the hazmat, fire and life safety, plan specifications reviews, and they are now fully fee-funded. So we have been able to increase their staff to do the checks on the buildings and as often as we think we need to, which is at least once a year. Cyber defense was our newest division, and that was created several sessions ago. Still a small body of 4, looking at helping all of our partners, whether they're private, counties, cities, work on the cyber defense preparation programs, various different security implements that they can use, formats that they can use, training, that sort of thing. And I don't know if it's finally, yeah, I think it is. Our Records, Communication, and Compliance Division, they do so much, and you will probably be seeing Erica. Erica, can you? A lot. You'll have questions for her because just about every decision this body makes impacts our division, even if it's as minimally as changing the NOx, the Nevada offense codes. So all of that is Erica. We keep track of all of the statutes that are coming through to try and guess at what kind of impact it will have on their team. Right now, anything has an impact because, again, we're short-staffed. And the civilian in her area are very, very short-staffed. And we're talking admin 1s, 2s, and 3s, and then some project folks. So they're at the lowest end of the state scale, so they definitely are difficult to hire and certainly hard to keep. You'll see on page 21 all the different programs that the Central Repository handles. They're significant and unique and separate, using all kinds of court assessments to fund, as well as general fund and fees. So they definitely stretch every dollar just to get where they need to get. They're also the home of Insidious Mod. That's our crime software system, management system for the entire state. So all the counties and cities are dependent on this program, which is our connection with the FBI. And this is the final year. So once we get through this year, the 24-25, we will be moving into maintenance on the system. And our systems will be so much more efficient that we will be able to handle some things with fewer people, where people can just use the system and not have to wait on the phone for us to answer. Then we'll go into our maintenance mode, which will be long-term. We won't take our eyes off this baby one time and keep upgrading, keeping up with it at current times rather than letting it get rusty and old and then having to start anew. Oh, and the Office of Criminal Justice Assistance is one of our granting agencies, and it's an office of 5 who go out and find as many grants as they possibly can for us, but they're also the pass-through for the Office of Justice, the Federal Office of Criminal Justice. Moving on to parole and probation. You heard several times, parole and probation does this, parole and probation does that. And like I said in the first slide, they have been hit as hard or harder than highway patrol in terms of vacancies. And so our officers' caseloads are so significant that it is of serious concern that the offenders can be supervised properly. When you have a caseload of 145%, somebody's not going to be seen. On the other hand, we're doing very well with our PSIs, and so our PSI writers are filled. We are taking care of the reports in a timely manner. I don't think you'll get any complaints this year, but with our officers, it is significantly a concern. We have had conversations with quite a few judges in terms of trying to get some of the details wrapped up, things that are missed in reports, that sort of thing. But we're almost there. And with parole and probation, we also have Otis, which is the management system for parole and probation that's been dying for years and years. And we are halfway through, almost 3/4 of the way through. We will finish this biennium, the upgrade of Otis 2. And once that happens, we do believe that we will have much more ability to run statistics, for example, because everything is done by hand. We'll be able to handle our fiscal processes so much better because it'll be tied to fiscal, and right now they're completely separate. Moving on, what's that? No, I missed communications, which is dispatch. Similar situation. We have had to close our Carson City office because we don't have enough dispatchers. We have Las Vegas running 24/7 and covering for Carson at least one shift a night because we just don't have the staff. We bring them in, and it's a tough job. I think most of you have enough experience to know how hard that job is. And again, lower on the pay scale, so it's difficult to retain, very difficult to hire and find the quality people that we need. And I think I got everybody. And if you have any questions, I am here to answer them. Thank you.
Thank you for that. Thank you for your presentation. We do have a few questions. The first question will be from Assemblywoman Cohen.
Thank you, Chair, and thank you for the presentation. Can you tell me, going back to parole and probation, what happened to the Day Reporting Center from a few years ago?
George Tagliati for the record. We had, you're familiar obviously with the Day Reporting Center, which was, it fell under parole and probation, and in very brief terms, we were able to take approximately 200 people from Southern Nevada and 50 people from Northern Nevada and put them through a program, which allowed them to get their GED, get some drug counseling, and various services. It was a volunteer program, and it was in existence, I believe, for about three years, and we lost the funding on that. In the interim, we have engaged Hope for Prisoners, which is in Southern Nevada, with, I think, previous attorney Jones. Mr. Jones mentioned it. The John Ponder's group down there has been very effective. It's a not-for-profit on transitioning people from prison back to the communities. We have presently embedded, if you will, part-time of 2 officers from parole and probation within his unit in Las Vegas. And we hope to engage some of the people there and help foster that program. I've also had conversations with Mr. Ponder, encouraging him, and he's more than willing to proceed with this idea, but to definitely come up and get a facility going somewhere in the north, in Northern Nevada. I would recommend, if you have the opportunity and want to hear the story of Hope for Prisoners, that you inquire and ask for him, and I'm sure he'd be happy to come up and fill you in on all the details.
Okay, thank you, Chair.
You're welcome, thank you. Next question is from Assemblyman Gray.
Thank you, Madam Chair. Ms. Brueggemann, I too share your concern for recruiting and retention, especially being in the rurals. Heard a couple of rumors about the graveyard shifts going away in Carson and the Reno area. We greatly rely on them for backup at night, especially. With regards to your background investigations, though, have you guys taken a look at that and maybe, polygraphs are not admissible in court as evidence, but yet you guys will disqualify, a candidate for 18 months or even permanently sometimes based solely on a polygraph. I personally know a couple of people that have gone through that would have been excellent candidates that had absolutely nothing to hide, and you guys have lost out on those. One has actually gone to Sparks. But regardless, have you guys maybe thought about saying, okay, we've got a questionable polygraph, can we dig a little bit deeper into it before we actually make the decision to disqualify somebody? Because, that's old technology, and I'm partial to VSA, so maybe going, okay, if they fail a polygraph, go to a VSA or something like that, because this day and age, we need these good officers out there, and we've got to do something different. Thank you.
Sherry Brigham for the record. We actually spent a lot of time rearranging our backgrounds because we would be hundreds of backgrounds behind if going through it the way we did before. So last session we were able to pick up some more polygraph people who do both background investigation and polygraph. And you're right. We have found that the polygraph first we've been able to keep up with all of the backgrounds without having that backlog and get back. And we are finding close to a 50% fail rate. But I have to say, we do go back and look at some other things. The polygraph officer who handles it does not have the final say. It goes through the department, back over to the hiring authority. It's either the lieutenant and sergeant at Highway Patrol or lieutenant and sergeant in PNP who look at the facts there. We ask more questions, and I have to say the majority of our information comes from other law enforcement agencies that have already performed a background. So often that is the primary issue where we have more information than just the polygraph itself.
So I would like to follow up on that. So what you're saying is when it comes to applicants, there's a 50% fail rate with the polygraph.
There indeed is even higher percent fail rate in many different situations. By the time we get down to an actual hire where they haven't failed their physical or their the NTN test or the polygraph or the background or the psych, we get down there and we're down to a 1%, 2% at best. So yes, and that's always been the case. It's just that our applicants coming in, first of all, we don't have the same number of applicants coming in just because of the law enforcement issues going on in the world today. But even so, it's difficult, yes.
I appreciate that, and it's understandable that visual, when you say sight test and physical fitness test, those things can be corrected and improved, but it is concerning to hear, and this isn't necessarily a comment against the applicants, because we know all the dynamics that go into those polygraph tests and that there's multiple reasons for failures on those tests. So thank you for that. Our next question is from Assemblywoman Hanson.
Thank you, Madam Chair. Thank you for being here. We certainly are well aware of the deficiencies that you're facing, and I am tremendously concerned. I represent a lot of rural counties as well as an urban area. I have a specific question, but just on that polygraph, just to sort of add to the context, our son had pursued a law enforcement career at one point, and in the course of that, which was very onerous, which I understand why. The chief of police for Santa Barbara, California, came to our home to interview us as part of the process. He said, because we were stunned that they came all that way, and they were recruiting Nevada students at the university to go to California. He said 85% of applicants fail. And we were stunned by that. And I think one of the most eye-opening things we learned from our son is, luckily, he had been briefed by former law enforcement people that when it comes to the polygraph, even though you're worried about maybe something out there, everybody is, regardless. Just don't lie. And then if you pass the polygraph and you've answered in the affirmative to something that you're nervous about, then they can deal with that. So I guess the advice is just don't lie on the polygraph, even though you're concerned, because the other thing that you didn't lie about might not be a deal breaker in the long run, but lying is the deal breaker. So just from a personal perspective. And then if you could clarify what you said about not DUI, wrong way drivers. Do we have a breakout that those wrong way drivers versus just confusion, or the road is the problem versus the human is the problem with driving under the influence? Do we have a separation of those?
George Tagliati, for the record, thank you for your remarks on the polygraph. You're spot on. I think this wouldn't be really a scientific answer. I don't know if we have those statistics, but we can certainly try to get them for you.
Yes,
I think
Amy does.
Amy does.
With regard to fatal wrong-way crashes, 80%.
Oh, excuse me, please approach.
Sorry.
And you will also need to state your name for the record.
Thank you. My name is Amy Davey. I'm the administrator of the Office of Traffic Safety. I can't speak to the 800 wrong-way drivers that have been intercepted, but I can speak to our data on fatal wrong-way crashes. We do study fatal wrong-way crashes in Nevada, and we find that 80%, in 80% of those cases, the driver is substance impaired.
Okay, thank you. And I believe that's it for our questions. So thank you so much for your presentation. And if you have more information about the passage rates for the polygraph test and can submit that to the committee, we would greatly appreciate that. Thank you.
Thank you, Madam Chair. We'll be there this evening as well, if anybody has any questions.
Okay, great. Thanks so much. That doesn't technically count as an invitation because it was someone else's, but I appreciate the effort.
I'm going to take it as an invitation.
You're going to take it as an invitation. Okay, so our last presentation for today is coming from the State Board of Parole Commissioners, and we have Chair DeRico and Management Analyst Baker and Management Analyst Thrasher. So please approach. We'll give you a few minutes to get organized. Mm-hmm. Okay, so it looks like we've kind of settled where the room's kind of settled again, so please proceed when you're ready.
Thank you. Good morning, Chair Miller, Vice Chair Marzola, and all the members of the Assembly Judiciary Committee. My name's Chris DeRico, and I'm the Chairman of the Board of Parole Commissioners. Also available today with the Parole Board is Kathy Baker, our Management Analyst 3, and Matt Thrasher, our Management Analyst 1. Thank you for this opportunity to provide an overview to the Parole Board today. As you'll see on slide 2, the Board of Parole Commissioners consists of 6 members and 1 chairman. We are all appointed by the governor. I am the current chairman and have been in this position since July of 2018. Prior to being appointed as chairman, I was a commissioner starting those duties in 2017. In Las Vegas, we have Commissioners Christensen, Virtue, and Bailey, and in the north, we have Commissioners Jackson, Baker, Weisenthal, along with myself. So what is parole? Parole is a conditional release from prison. The court determines the initial parole eligibility. However, the minimum sentence can be reduced by credits in the state of Nevada. That is typically what we refer to as AB 510 credits. Parole is an act of grace. There is no right to parole. The state legislature has determined that. The Parole Board is primarily responsible for making parole decisions to either grant or deny parole. However, that does not mean that we approve or deny parole release plans. We make parole decisions, and favorable decisions are passed on to the Division of Parole and Probation. They investigate and determine whether a release plan is appropriate or if a subsequent release plan needs to be developed. We also return offenders to prison through the parole violation hearing process. We are an independent body. If you look at this chart of the Department of Public Safety management team, you will see that we are organized under them. Off to the side, in blue, you will see boxes that say administrative support provided to and Parole Board. But the Parole Board is not connected to the Department of Public Safety. What this tells you is that we're an independent body and we're established under the governor in terms of who sits on the board. Commissioners serve 4-year terms. We're a small agency with only 27 full-time employees located at 2 offices throughout the state, 1 in Las Vegas and 1 in Carson City. We're dependent upon the Department of Public Safety to provide administrative services to us. And since being appointed chairman, I can say the Department of Public Safety has provided outstanding services for us. This is the Nevada Board of Parole Commissioners organizational chart. You'll see that the chairman oversees the operations of the entire office. However, the chairman does not oversee the commissioners. We all work for the governor. The governor recommended budget included a newly created position for a parole board executive director. And if approved, this position will report directly to the chairman and streamline our work process moving forward. A majority of other states nationwide have this position within their parole board. If approved, a BDR has already been submitted, which creates a new statutory language for this position. Additionally, the parole board assists the pardons board, and I need to make sure we have two separate entities here. The pardons board consists of the governor, attorney general, and the justices of the Supreme Court. The parole board houses the pardons board executive secretary, who has one assistant. This staff reviews community case applications, and if they meet the appropriate criteria, the information is forwarded to the Division of Parole and Probation for further investigation. In addition, our office reviews inmate applications. A pardons board member may also sponsor an inmate case, and if so, the information is provided to the Department of Corrections for investigation and placement on an agenda. If an inmate is granted parole, the Division of Parole and Probation provides parole supervision. They do this by monitoring the parolee's residence, job, activities, associates, along with many other duties. The parole board does not have parole officers under it, and these supervision services are provided by the Division of Parole and Probation. We are two separate agencies. Conditions of parole may include drug testing and treatment, residential confinement, no contact with victims, or requirements to pay restitution, just to name a few. The Division of Parole and Probation enforces the conditions as ordered by the board. The parole board is part of the judicial system. Statutes give us our marching orders and tell us how and what we are supposed to do. The parole board offers the system some flexibility. It's not black and white. For example, an individual may be sentenced to a term of imprisonment for a term of 2 to 20 years. This does not mean that that inmate is going to serve 20 years in custody, and at the end of the 20 years, he or she will be released. Rather, it means a parole board may consider an inmate for parole at their minimum eligibility custodial term and decide if, for example, 2 years is enough time to serve in custody. The parole board may grant at any time between that hypothetical 2 to 20-year term, and in making these decisions, the parole board needs to consider whether a particular inmate can be released and safely supervised prior to the expiration of their sentence. We conduct many types of hearings, and I'll briefly explain them to you now. A discretionary hearing is exactly that. It's at the discretion of the board. And when an inmate is eligible for parole, the board will conduct a hearing to determine if it's the appropriate time to release the particular inmate to parole supervision. The decision is up to the board. It takes 4 commissioners to affirm a decision, either negative or positive. It's never one person deciding anyone's fate. Additionally, we have mandatory parole hearings. These are generally held if the inmate was not granted parole at a discretionary hearing. It is the last chance to get out of prison a little early with supervision. Mandatory parole is set by statute, and the primary consideration of the board that the board must consider when deciding whether or not to grant or deny at a mandatory hearing is whether the inmate is considered a danger to public safety. While there are many considerations for a discretionary hearing, the primary concern for mandatory parole hearings as set by statute is public safety. Recently, because of AB 236, which passed in the 2019 legislative session and effective July 1, 2020, the board can now grant mandatory parole in absentia on certain cases as long as the inmate has served 3 years or more on the effective sentence, does not have a consecutive sentence, has not previously been granted parole on the effective sentence, and they are eligible. To do this, the board reviews files and determines whether to grant mandatory parole in absentia. Some considerations for this type of in absentia mandatory parole grant may be whether there are victim notification requirements, the severity of the crime, and the risk level of the inmate. If it's determined that the board may not grant mandatory parole in absentia, an in-person hearing will be scheduled. As part of AB 236, the board now can conduct geriatric parole hearings for qualified inmates. To qualify, an inmate cannot have been convicted of certain crimes, for example, crimes of violence, crimes against a child, sexual offenses, or vehicular homicide, nor do they qualify if they've been found to be a habitual criminal. If an inmate is serving a sentence of life imprisonment without the possibility of parole or sentenced to death, they also do not qualify. Essentially, these inmates must not pose a significant and articulable risk to public safety. Lastly, they must be at least 65 years of age and served a majority of the maximum term of the sentence. These hearings are conducted in the same general manner in which other inmates are considered for parole. The board also conducts reconsideration hearings. An example of this may occur when an inmate who is granted parole but not yet released is subsequently found guilty of a major rules violation while in the Department of Corrections. In these types of cases, the Department of Corrections generally provides the board with notification of the rule violation. These violations may be for very serious things, such as assault and battery or some other type of serious offense, or it could possibly be for something not quite as serious. In a reconsideration hearing, the inmate will be scheduled to see the board again, and the board will review the details of the violation and deliberate on whether the violation is serious enough to change the previous position to grant parole. The board also conducts parole violation hearings, which result in either a return to incarceration or a release back to the community to satisfy the original requirements of parole. As part of AB 236, if an individual is found guilty at a parole violation hearing of committing only technical violations of supervision and not for committing certain misdemeanor, gross misdemeanor, or felony offenses, or from absconding from their supervision, the board may temporarily revoke an individual for a shorter period of time, up to 30, 90, or 180 days, and then have them reinstated. I'll provide additional information on temporary revocations later in this presentation. As a part of AB 236, the board may conduct early discharge hearings. A parolee must meet certain requirements to qualify, such as having served at least 12 months on parole and have less than 12 months of parole remaining, no violations on supervision within the preceding 12 months, current with their supervision fees, paid restitution in full unless waived by it's been determined by the Division of Parole and Probation that there's some type of economic hardship, and they have to have completed any substance abuse or mental health program that was ordered. The Division of Parole and Probation starts this process and recommends it when it's inappropriate. The board also conducts lifetime supervision hearings. Lifetime supervision is imposed upon sex offenders who have met the statutory requirements of their sentences, either through completion of probation, parole, or completion of a custodial term. These offenders have an additional term of supervision of at least 10 years to life, and they are supervised by the Division of Parole and Probation. The board by statute is required to set those conditions. If someone violates the terms of lifetime supervision, the board is not involved. This is considered a new offense, and this matter is dealt with through the court system. This slide reflects our actual numbers for fiscal year 22. Looking at NRS 213.131 subsection 3, which was written many years ago, it states that meetings to consider parole may be held semi-annually or more often. I can tell you the parole board generally has hearings scheduled every day of our work week. In fiscal year 22, the parole board made 5,831 actionable final decisions. Each of these decisions require a minimum of 4 votes to ratify, which equates to approximately 23,324 decisions entered by commissioners in the last fiscal year. If you include the hearings that did not result in a final parole decision, we held approximately 6,955 hearings during fiscal year 22. Also, each order requires a commissioner's original signature. This duty is rotated among board members. As previously stated, we conduct hearings both north and south to include violation hearings every day of our work week in both of those offices. We have 4 hearing rooms, and when necessary, we use all 4 of them at the same time. This slide shows our actual caseload beginning with fiscal year 2018 through projected fiscal year 2025. The projections were taken from James F. Austin Institute, which we refer to as JFA, the fall 22 forecast. JFA is a contracted consulting firm and is a current vendor who prepares a report twice a year for the Department of Corrections to assist in determining the prison population forecast. JFA looks at the state's data, and they project what the workload and caseload will be like for various state departments so that agencies can project forward and look at budgets and staffing. The figures for fiscal year 2023 are based on 6 months of actual hearings, 2,944, to include discretionary, mandatory, and violation hearings. These hearings also reflect any hearings that resulted in no action. Additionally, JFA has projected that our second half of fiscal year 2023 will result in 2,711 hearings. These hearings include all parole-related hearings. The violation hearing projections are based on JFA's assumption that there will be a 2% increase to parole violators moving forward. These assumptions are based on the JFA draft 10-year prison population projections encompassing the years 2022 to 2032. We also compare cases by offenses. This chart shows you 5.5 fiscal years of parole consideration hearings by general offense type. This chart represents parole actions by offense group as defined by the Department of Corrections. Offenses appearing in the sex category also include offenses such as prostitution with HIV, pandering, and failure to register as a sex offender. Of note, offenses that involve violence during the commission of the offense, but where the actual conviction was for an offense that would not by itself appear to be violent, will not appear in the violence offense group. For example, a burglary conviction that included striking a residence would appear in the property offense group. Offenses appearing in the other offense group include offenses that cannot be readily categorized in one of the other offense groups. For example, habitual criminal, gaming-related offenses, or cases with victims over the age of 65 if they're an enhancement. Remember, these also could have been for a violent-related offense. We have included the actual numbers for the first half of fiscal year 23 on this chart as well. What we're seeing now in the first half of fiscal year 2023 is a small decrease in the caseload over the past year. You can see that if we continue this trend, we will conduct approximately 4,722 actionable parole hearings in fiscal year 23. Remember, the above numbers do not include violation hearings, continuances of hearings resulting in no action. This next slide breaks down the percentages of inmates who are granted parole based upon offense types. However, I want to point out that there was a significant increase in the granted parole percentages for fiscal year 2020. The total grant rate for fiscal year 2020 was 71%, which is considerably higher than in past fiscal years. The reason for the significant jump had to do with COVID-19. On March 15, 2020, Governor Sisolak closed the state offices to the public. However, per statute, all our parole hearings must be open to the public. That left the board with looking to find a way to move forward during the early months of COVID-19, especially since the Department of Corrections had already closed their facility to visitors around March 15, 2020. This left the public with nowhere to attend a hearing. Certainly the board did not want to defer hearings out until whenever state offices were once again open to the public. If we would have done that, we would have created a backlog of inmate hearings down the road. And in addition, had we done that, it would have denied certain inmates the opportunity to release to the community in a timely manner when they were eligible. What the board could do was grant parole to inmates without a meeting if they met certain requirements. I want to make sure this point's very clear. The board can grant parole without a hearing in certain cases, but we cannot deny parole without a hearing in certain cases. Statute doesn't allow that for us to do that. As a result, the board went through the files for all inmates by hand who were eligible for parole in the second half of March, all of April, and May of 2020. We're able to grant parole and abstention for those inmates that would have likely been granted at an actual hearing. For the cases where parole would likely have been denied or a hearing was necessary or additional information was needed or requested, no action was taken only on these cases, and they were rescheduled for a subsequent hearing, which began as soon as June of 2020. However, by moving forward on the cases that met the requirements, our grant rate percentage for the month of March 2020 was 74%, which was significantly higher than our other months. Additionally, our grant rate percentage for the months of April and May of 2020 were 100%. We couldn't deny anybody, only people were getting approved. Since hearings were not held during that time period, it inflated our grant rate percentages for fiscal year 2020 as a result. Of note, our offices were closed from approximately mid-March through May 30th, 2020. Once the governor allowed state offices to open to the public again with social distancing requirements in place, in June of 2020, our grant rates returned to their normal average. As a result of AB 236, the board now conducts violation hearings a bit differently depending on the nature of the violations. As previously stated, if offender is found guilty of only a technical violation, there is an incremental revocation period that must be imposed, followed by reinstatement. A technical violator must progress through the 30, 90, and 180-day temporary revocation process before being able to be fully revoked or within the statutory limits. Remember, temporary revocations do not apply to an offender who has been found guilty of certain new crimes or if they have absconded from supervision. This chart details the amount of temporary violation revocations and reinstatements for fiscal year 21. Since the enactment of AB 236, we're conducting multiple hearings on the same parolees as a result of temporary revocations. This next chart details the amount of temporary violation revocations and reinstatements for fiscal year 2022. We're already starting to see individuals being returned for their second, third, and fourth technical violation. Prior to AB 236, there'd only be one violation hearing, and if they were revoked, the board would later conduct a subsequent discretionary parole hearing on the revoked inmate to determine their suitability for another opportunity of parole if they were revoked to the expiration. In closing, I want you to understand that we're a small agency. We're a full-time board, much like the Gaming Control Board. But even though we're small, with only 27 budgeted full-time employees, our impact on the state of Nevada is large. Our primary role is to conduct hearings and make decisions to either grant inmates releases to the community under supervision when appropriate, or to deny those inmates that may pose a risk to public safety. Certainly, the cost of community supervision is much less than supervising individuals in an institutional setting, and our commissioners and support staff are very aware of this. Our staff works very hard to do what we can to serve the best interests of all citizens of the state of Nevada. If any of you would care to spend a morning or afternoon observing our hearings, please contact me. We'll welcome you, and once again, they're open to the public. Lastly, our website address is on this slide, and there's additional information that can be found there with regard to our quarterly and annual reports. Thank you for allowing me to present today, and if any members have any questions, I'll answer them to the best of my ability. Thank you.
Thank you. We appreciate that. And I also appreciate the very concise, basic definition of parole at the beginning. I keep urging everyone that that's presenting is that, and it's partly our fault because we use certain terms interchangeably, parole and probation, jail and prison, but the average person doesn't always know, and we can't assume that everyone in our committee knows those distinctions, and those are vital distinctions to know when we're, in the legislative space. So thank you for that. With that, I will open it up to questions, and we will begin with Assemblywoman LaRue Hatch.
Thank you, Madam Chair, and thank you so much for coming today to present. So I had a question on slide 11, which talks about the caseload, and I noticed that since 2020, there has been a significant decrease in hearings, and it looks like that trend is projected to continue, and I just wondered if you could explain the cause of that decrease.
Chris DeRico for the record. I'm just flipping here to slide 11. So this is one of those things, and I'm sure you'll hear a lot moving forward, is since in 2020, COVID certainly had a significant effect. Less cases, we're seeing less cases in entering the prison system. I know you had a presentation on Tuesday from the Department of Sentencing Policy and looking at a lot of those things, but there weren't as many prosecutions. The intake wasn't going up as high there, and but we, at the board, continued process and do our parole hearing. There's no stop there. Someone's eligible for parole, we're going to see you. We're going to hear you. We're looking to move forward every time. So who comes in? But parole violators potentially could increase those numbers and increase our hearings. But everything projected down, a lot having to do with COVID. We could say some of the effects of AB 236 in the 2019 legislature as well. But overall, this is where we are now. The prison's down significantly, and I think, as you're aware from your other presentation on Tuesday, right now it's we have the more serious offenders that are left in there, and those ones that can be most likely safely supervised on the streets. Those are the ones we're trying to get out, and I hope that answered your question.
Yes, and I think that's fair to say. I mean, I'm not one to just put everything on COVID, but I think all of our data across all social sciences, anything dealing with human behavior or activity, have been altered because of COVID, and we can't take those as, the specifics or even trends. So thank you for that. With that, we have another question from Assemblywoman Mosca.
Thank you, Chair. Thank you for the presentation. Can you please share more about the background of the commissioners, how long the term is, just so I can have more background knowledge? Thank you.
Yes, Chris Rico for the record. So the background, statutorily, I don't have the statute number in front. In Chapter 213 is what governs the parole board statutes. And statutorily, the parole board commissioners' appointments are 4 years, and they serve at the pleasure of the governor. And in statute, you have to have backgrounds, and I'm going to go through and I'm going by memory. You have to have experience, a degree and experience or background in law enforcement, parole and probation, corrections, substance abuse, mental health type counselor. There's 6 categories. A prior district attorney or public district attorney or prosecuting attorney, and so there's this kind of, fit in a package here of what needs to be, what qualifies in here. And so everybody on our board has those, fits into that mold within the restraints for the government to appoint.
Thank you. I don't see any other questions from members, so thank you for your concise and informative presentation. With that, we will go ahead and close the presentations, unless you have an engagement you'd like to invite us all to.
I was thinking about that, and nobody, as I feel like that old commercial. I like tacos. And I'm like, who invited me? But anyway, no. So I don't have any parties, but in 2 years, hopefully, I'll plan one. Thank you.
Okay, thank you for that. With that was the end of our presentation. So we will move to our next agenda item, which is public comment. And again, just to remind everyone that everyone will have up to 2 minutes to speak to something that's under the purview of this committee. I'm going to give the phone number now for those who wish to call in to make public comment. Our phone number is 1-669-900-6833, and the meeting ID is 88546-543-926. Again, the meeting ID is 885-465-43926. Just so everyone understands, our phone number to call in for testimony will stay consistent every day, but our meeting ID will not. So for those of you listening that are writing it down, I don't want you to assume that's the meeting ID for every day. With that, anyone interested in making public comment that is here in Carson City may come ahead and approach. And broadcasting, again, please open the lines.
Good morning, Madam Chair, members of the committee. Tanya Brown, spelled Tonja-Brown, Advocates for the Inmates and the Innocents. There are some new members here, and I just want to give you a brief history of who I am and why I became an advocate for the inmates and the innocents. In 1988, 35 years ago, a crime was being committed in Sparks, Nevada. My brother, Nolan Klein, was playing pool in Jack's Bar in Carson City, which is now the Bank Saloon across the street, to give you an idea of how the distance. He had 5 alibi witnesses testify he was playing in Carson City, playing pool in there during the time this crime was being committed. About 2 weeks after the crime occurred, he was picked up for questioning. A detective put together what we'd call a tainted photo lineup. This type of photo lineup array is no longer being used by Nevada law enforcement agencies and throughout other agencies throughout the country because it's the #1 leading reason why there are wrongful convictions through misidentification. Today, we heard from the district attorney's office, and I want to speak to that, the evidence they collect and how they turn it over to the defense. My brother spent 21 years in prison for a crime he didn't commit. In 2009, the Honorable District Court Judge Brent Adams issued an order to Washoe County District Attorney to turn over the entire file in the case. When the file was turned over, all of the exculpatory evidence showed was hidden from the defense, including another suspect. Just as his attorneys were about to file motions for new trial and bail, he passed away. He died, never being exonerated, never being cleared of his crime. 2 years after he passed away, I found the suspect who committed the crime. 23 years later, 2 years after his death. We have been working on getting legislation throughout the years, and through our advocacy and other advocates, we have helped in order to help the innocent.
Thank you, Ms.
Thank
Brown.
you.
Your 2 minutes are up, but again, I know you are here in the building and we'll have the opportunity to share the rest of your story. Thank you so much. Not seeing anyone else here in Carson City, also not seeing anyone in Las Vegas. Is there anyone on the phone? I believe we may have a few people online to call in, broadcasting.
To provide public comment, please press raise hand in your Zoom or *9 on your phone to take your place in the queue. Caller, you are unmuted on our end. You may begin.
Hi, my name is Eileen Carino. I'm a national advocate for guardianship reform and an anti-corruption activist. I've been following the Washoe County Susan Hilligus guardianship case since 2018, which led me to follow the 2019 Roger Hilligus and Stuart Hanty alleged criminal case. That was a great presentation today given by the district attorney's office, so I hope to see all of that going forward. However, what I'm witnessing out of Washoe County currently in this case are no due process, 50 pieces of missing exculpatory evidence, violations of their protected constitutional rights, falsely imprisoned, no remedy for 4 years. Roger Hilligus is currently in jail with no bond, and he has been in jail for 5 months. We would like to see him freed. The mental health evaluation that Barry Breslow ordered appears to be unconstitutional, that he doesn't have jurisdiction based on the list versus 8th Judicial District Court dated 12/30/2021. And currently, Stuart Hanty, a 30-year retired law enforcement officer in good standing, has an unconstitutional GPS monitoring device that is in violation of his Fourth Amendment rights according to the Supreme Court case Grady versus North Carolina, 2015. I have questions. If your mom was being abused, would you want to help her? If you were innocent and you were in jail, would you want to be held for 2 to 4 months in jail? And aren't we innocent until proven guilty? Why are people being imprisoned without a hearing? Thank you.
Thank you, caller. Next caller, please.
Caller, you are unmuted and may begin.
Hello, my name is Elena Stainbrook, and I am also a national advocate like Allie Carino for guardianship reform and guardianship abuse. And I'm calling in for the case with Roger Hilligus, his mother Susan Hilligus, and Stuart Hanty. And I just would like to second everything Allie's saying. There's been a lot of false allegations from the district attorney's office regarding the character of these two men that I know, and they are very good men, and they have hearts of gold, and they would do absolutely anything for anyone. and they're being unlawfully imprisoned. And I just would like answers to the questions that Allie asked as well.
Thank you so much, caller. Next caller, please.
Anne Marie Grant on behalf of Advocates for the Inmates and the Innocent. In August of 2022, I put in a request for an updated number of cases reviewed by the Washoe County DA's CIC unit since 2018 when I put in an initial request. In contrast to the first request in which I was told one case had been reviewed, they are now telling me that they have reviewed 2 cases since 2018. The stark difference in the way the 2 cases were handled by the CIC unit is telling. While there were no alleged prosecutorial misconduct, aka Brady violations or withholding of evidence in the second case, the first case calls into question the conduct of the prosecutors who tried the case. There are clear Brady violations in case number 1, as well as the CIC unit being provided newly discovered evidence they did not review. What does the unit do when Brady allegations are made? They don't look at anything provided to them when it impacts one of their own and choose to protect their predecessors rather than seek true justice. Truthfully, the CIC unit appears to be a dog and pony show and further proof as to why we need legislation. With a posthumous exoneration bill, the wrongfully convicted would not have to rely on the unrealistic expectation of ensuring the same agency that perpetuated the injustices makes a sincere, honest attempt at fact-finding. My brother Thomas Purdy was hogtied and died at the Washoe County Jail where Roger Hilligus is being held. Roger has reached out to many of us. He is being denied medical care. Other people at that jail are being denied medical care and Eighth Amendment rights. My brother died there and 2 other men died there. This has to be taken seriously by everybody and anybody who is an elected official. Thank you.
Thank you, caller. Next caller, please.
If you would like to provide public comment, please press raise hand in your Zoom window or *9 on your phone to take your place in the queue. Caller, you are unmuted and you may begin. Caller, please unmute your phone on your end. You are unmuted on ours. You may begin.
Yes, my name is Angela Campbell, and I am an advocate, elder abuse advocate, and I'm here for Roger Hilligus and Stuart Hanty, and I have watched and witnessed some of the things that are going on in their case. I have some questions about, how they're being treated and how their case is going and the process of their case. I agree with Allie and Elena that it is not being handled in the way that was presented today. I think you did an excellent job in presenting, but I think there's a disconnect from what you are saying and the things that are happening in the system. I would like to see some changes that are made, that it will be, as you are presenting, it would, take place like that. I think that there needs to be some maybe reforms in that process. So if you could please, make sure that whoever is overseeing these programs will be able to put in effect what is being presented today. Thank you.
Thank you, caller. Next caller.
If you would like to provide public comment, please press *9 to take your place in the queue or raise hand in the Zoom window. Caller, you may begin.
Good morning. This is Mercedes Maharis, Nevada chaplain and member of the Nevada Silver-Haired Legislative Forum, Las Vegas, Nevada, Senate District 3. I have 2 items. I would like to know what the law is that allows parole board to send individuals back to prison on their technical violations or any other violations. And I would like to know how many there are that are back in prison because of the parole board's technical and other decisions. I think that this is wrong. Nobody should be sent back to prison without new charges and going through the courts. Where is the law that allows this? Number 2, polygraphs need to go. They are unreliable and a form of torture and intimidation and forcing someone in a very uncomfortable situation, which damages nervous systems in the process. I think that the great number of people being sent back, reportedly 700 in High Desert State Prison. I don't know the other numbers in other prisons, but we need to find out. And parole is weighted with people from law enforcement. I think that is showing bias in the system. And there need to be medical and social workers on the board.
Ma'am?
But actually, I
Ma'am,
think that we need
thank you
to
so much for your
disband
comments.
the board.
Excuse me, ma'am. Your 2 minutes are up. If you have any additional comments that you'd like to make, we invite you to email them to us, please. But thank you for your comments.
Thank you.
Next caller.
If you would like to provide public comment, please press raise hand in your Zoom window or *9 on your phone to take your place in the queue. Chair, the public line is open and working. However, we do not have any other callers wishing to participate in public comment at this time.
Okay, thank you. So we will go ahead and close public comment. Just a few announcements. Tomorrow we will have presentations from the Gaming Control Board and the Department of Corrections. I just want to thank all the members for your attention and decorum today. And with that, we will see you at 8 a.m. sharp tomorrow morning. We are adjourned.